All right. So this is what you want to talk about at the end of the day, securities laws. But just to provide a little bit of a preview, that's what I'm going to primarily be focusing on. Now, thanks, Tom. I'm not a politician. I don't make the rules, so don't blame me for them. But I will be discussing them a little bit. But I did spend the last few years heading up the risk management departments of FTX, Alameda, BlockFi, Celsius, Voyager, and Genesis. And so that was a joke. They're all bankrupt. So I had nothing to do with that. I was just trying to build credibility to talk to you today about compliance. So, I mean, basically the goal here is to provide a high-level overview about the regulatory environment, focusing on the most important legal considerations that honestly have potentially existential implications for many blockchain projects out there. And again, that's where it all comes back to securities law. But the goal is really for those of you that are participating in the industry, hopefully you can do what you can, at least, to avoid crippling regulatory fines and maybe stay out of jail. Now, unfortunately, this isn't necessarily the easiest task for most people and participants in the industry. I mean, the thing is, there is an alphabet soup of regulatory agencies and laws, rules, regulations, thousands of them that apply to the American economy today. And many of them, the depth and breadth of which are expansive enough to capture even brand new industries that the lawmakers or regulators didn't anticipate or even think of or have in mind or even knew could exist at the time they implemented the rules, but it doesn't mean they don't apply. So the thing is, the real question is, I mean, a lot of people say the entire space is unregulated, no rules, no consequences, Wild West, you do what you want. But the thing is, in light of everything that was listed on the prior slide, all of those things apply to various degrees. And so really the question is there a thoughtful, relevant regulatory framework governing the industry that attempts to balance purported public policy goals such as investor or consumer protections while still facilitating an environment that fosters innovation? No. I think the answer is no. Now, I've been told that I'm terrible with PowerPoint, but these visual aids, top notch. And yeah, thank you. You can't convince me otherwise. So the problem isn't that the crypto industry is unregulated necessarily, but there is an issue here. And the problem is that many of the rules or regulations that do arguably apply, they have unclear applicability, are inconsistently applied, and generally lack a cohesive framework pursuant to which industry participants can rely upon. That's an issue. Now, I'm a corporate securities attorney, for better or worse, so I'll be focusing primarily on the SEC, and this is frankly appropriate as I really do believe that securities laws and regulations present arguably the biggest regulatory challenge or cynically threat to the industry today in America. I mean, it's different in other countries, but this is what we're dealing with. So, basically, just to preview where we're going, as we'll discuss, the current framework of analysis regarding whether crypto assets or tokens are considered a security and therefore subject to all the securities laws and regulations that are out there, I would argue is far from objective, in spite of what the SEC would tell you. Now, we'll get into the details, but to preview the implications here, I think this is, honestly, I mean, we have 30 minutes here, right? We don't have 5 hours. So I will be generalizing a few of these points, but I do think it's a fair thing to say that generally speaking, if a crypto token or asset is designated as a security by the SEC and is therefore subject to all of the laws and regulations applicable to securities, there's currently no feasible way for most of these crypto protocols or projects to exist as intended and remain compliant. I mean, it really is basically an existential issue. And the reason for this is that securities regulations, they trigger massive disclosure requirements, and really they have restrictions on the free transfer of securities themselves. And both of these concepts are not compatible with the smooth operation of a decentralized blockchain protocol. So basically, just to sum it up, the goal for now, based on what we have right now, is, you're trying to figure out a way to have a crypto asset or token not designated as a security. So, we have the SEC here. Now, regulators that want to facilitate transparency and clarity and encourage regulated entities to continue to operate compliantly, and they typically provide guidance or no action letters. They tell you what they're thinking. They give you a little bit of an insight into how they make their enforcement decisions. The thing is, the SEC has provided very little helpful guidance when it pertains to the crypto industry regarding, is Bitcoin, is Ethereum, is Ripple, is any of these tokens or assets, are they securities? There's been some guidance, which we'll talk about, but not a lot. But at the same time, the SEC has broadly asserted general authority and jurisdiction over the entire industry. In fact, to my knowledge, the SEC, I think, has provided zero guidance since around 2020, but instead they've filed over 760 enforcement actions. So they've been very active, but they don't tell us a lot about how they think about it. So basically, we're stuck with this uncertain environment, and to make things even more challenging, when everything's so uncertain, the defendants in these actions, they typically settle. The SEC comes after you, and you say, okay, well, is this a security? I don't know. SEC, will you tell us what you're thinking of? Under what conditions would this be a security? Would this not be a security? Not a lot of dialogue there. So they just settle. That's easier. Nobody wants to spend the amount of time and money that it takes to end up in a law school textbook. Honestly, that's a tough hill to climb. So what does that mean? Well, there's a lot of enforcement actions, but when everyone settles, we don't learn anything. There's no judicial precedent, and people just settle quietly outside of court, and they'll just keep going with their enforcement actions, but we don't know. We can't look forward and figure out what any of this means. So basically, this general state of affairs, I guess I'll go back to the other slide here quick. The general state of affairs, this is often referred to as regulation by enforcement. It's a critical term, perhaps a little pejorative, but it emphasizes the lack of forward-looking guidance and the perpetual nature of the uncertain environment here, right? Basically, if you operate in the industry, you have to take your best guess regarding how the SEC thinks about your crypto asset or token, and either you'll get sued, maybe you won't, but you likely won't know why. And that's the thing. Now, all of that said, we are going to focus for the rest of this talk about the few exceptions and review what we do know about what the SEC has said about various crypto tokens, see what we can glean from that, and talk about how we go forward from here. Okay, so with that in mind, let's take a little bit of a step back. I've thrown around the word security all day. Many of you know what that means, but of course it has a legal definition. What do I mean by that? And again, I would think of it very generally as an investment instrument. The Congress passed the Securities Act in 1933, defined what it is, and they did so shortly after the Great Depression to set in place a federal framework of regulation of securities of the entire country. There's the legal definition. They have enumerated items of investment instruments that have very clear meanings: equity, debt, different types of each. And so one thing you'll notice here, Bitcoin isn't on this list. We don't see digital asset on this list. So why does the SEC think that they have jurisdiction over the industry at all? Well, it comes down to this investment contract. So Congress added investment contract to the list. They likely did this on purpose to be kind of a catch-all, because they did want the SEC to be able to regulate investment instruments generally speaking. They were probably concerned that maybe if we keep listing them out, we'll miss something. We don't want any loopholes. But the thing is, you can understand where they're coming from, but that being the case, almost by definition, you're not really defining what it means. I mean, they just say investment contract. So, again, what does that mean? Congress, again, didn't define it. So, what do? I mean, basically, when Congress passes an ambiguous law of massive scope, then it eventually finds its way to the Supreme Court. Now, this is not a current picture of the Supreme Court, but it will do for our purposes. Some of you are probably familiar with this too, but basically, the definition of investment contract had to make it all the way up to the Supreme Court, and they developed what we refer to today as the Howey test. And the Supreme Court had to say, an investment contract exists if there is an investment of money in a common enterprise with the expectation of profits based on the efforts of others. Now, that's the test. That's what we have to deal with. And to bring this all back to the SEC's position, their position is that this is crystal clear. No further guidance required. This is it. This is all you need. And so just look at Bitcoin, look at Ethereum, look at any other crypto asset. This is your answer. And that is their position right now, which is interesting. But as you'll see, especially based on a recent case that we'll discuss a little bit, it's not accurate. I mean, reasonable minds can disagree on how you apply this test to various crypto assets. So with that in mind, let's talk about what we do know. The SEC has made some comments. It has provided some guidance. So let's talk about what we do know based on what they've said to date. What about Bitcoin? They have actually indicated that Bitcoin is not a security. It's not an investment contract. I mean, sure, there's investment of money. Sure, you expect some profits. But it's the elements 2 and 4 that are a little tricky. And the SEC even said that does not exist. It basically comes down to the idea that Bitcoin is sufficiently decentralized. I mean, if you purchase a stock in a company, there's a board of directors, management, and you're investing in that organization, and you're assuming that these people are going to take action to increase the value of your investment, doesn't really apply to Bitcoin. I mean, there is no board of directors. No one controls it. So this is helpful. I mean, this isn't nothing, but unfortunately, there's a lot of different types of blockchain protocols out there, and not all of them are exactly like Bitcoin. So what about Ethereum? The Ethereum network, what about Ether? We have some insight into this as well, but the moment we turn away from Bitcoin, things get fairly muddy pretty quickly. Ethereum, the SEC has indicated that they do not think Ether is a security either, but this is a little dated. This is as of a few years ago, when the Ethereum network was operating under the proof of work consensus mechanism. So this is not applicable anymore. And in fact, Gary Gensler, chairman of the SEC, has already publicly stated that he thinks following the switch from proof of work to proof of stake, he thinks Ether is a security. And why would that be? Well, basically, proof of work, proof of stake, in connection with proof of stake, your ownership of the token itself, there's a relationship to governance. And all of a sudden, it starts to look a little bit closer to stock, where if you own equity, if you own enough, you control the company. And so that's where they're coming from. But again, it's a little gray. We don't know. All we have are comments. We don't have any ruling on it. There's no official guidance. But basically, the only thing we can say for sure is Bitcoin, not a security. Ether, maybe. So with that, why are we going to talk about Ripple? I mean, Bitcoin, Ethereum, that makes sense, but why Ripple? I mean, that's kind of random. There are hundreds or thousands of other crypto tokens we could talk about. And frankly, Ripple and XRP, I mean, it's arguably a little bit more centralized than a lot of the other protocols out there. But the Ripple organization actually did not settle with the SEC, and that's why we're talking about them right now. This is the best information we have from a judicial perspective. regarding how do securities laws apply to the crypto industry. Because they were sued recently. The case is still going on, by the way. But we're going to talk about a couple issues from the case and how the court came out on this. And we're going to talk about there were a lot of things that this case talked about, but we're going to just zero in on a couple things. So basically, the sale of XRP to institutional investors, but also programmatic sales sold on digital exchanges. And this is actually kind of interesting. They came out with different decisions on each factor. So institutional sales. Again, you have Ripple, basically like a company. They're affiliated, and their affiliates. They're selling XRP directly to professional investors pursuant to written investment contracts. So there's clearly investment of money. They found a common enterprise. They obviously were expecting profits out of it. Based on the efforts of others, this was key. Ripple did promise that they would take certain actions that would increase the value of the XRP that they sold to them. They promised in the investment contract and also outside of it. So they said yes. This was an unregistered sale of securities. Here's where it gets interesting. Essentially the same thing happened, only on an exchange. Blind bid-ask transactions, you don't know who you're buying from. So they said no. I mean, sure, there's an investment of money, but the court found that in this scenario, buyers didn't know they were buying from Ripple, even if they were. So how could they expect that they would take action to increase the value of XRP? Now, this is interesting because the vast majority of transactions in the crypto sphere happen like this. So, I mean, are we done? Is this, is the entire industry saved? Well, let's take a look at the implications. Basically, crypto assets, unlike stock or bonds, they're not securities in and of themselves, but they can be. And again, this provides the best insight that we have available into when it is or is not a security. So is the issue settled? No, it's not. I mean, basically, the SEC, this case is ongoing, for one. Two, the SEC did lose a bid for an appeal while the case is still ongoing, because I think that goes to the same judge. So basically, you're asking the judge, do you think you made a mistake? And the judge says, no, I think I did not make a mistake. So, I mean, fair enough. But the thing is, other district courts could come to different conclusions. And so unless and until this issue of how the Howey test applies to crypto assets or tokens goes to the Supreme Court, there's no truly binding precedent. And the thing is, we already have seen indications of this. There was a New York federal judge already disagreed flatly with this Ripple ruling in a different case. And so this is going to keep going on. So what do we need? It comes full circle. Congress needs to do something. They really need to step in. They need to tell us, where does the SEC's jurisdiction start and end? Or the SEC could decide, following the Ripple case, they could also decide to tell us what they think a security is or is not. But clearly there's a big disagreement between what the SEC thinks is a security and at least one court and a number of different organizations. Now, I know we're running behind, just generally speaking. Okay. So there's an end to this. This will take 5 minutes. How many of you mine or stake any kind of crypto asset? Okay, then this will be worth it. I thought this was somewhat interesting. Again, no conclusion, just like the rest of this presentation, no conclusion at all. But I thought this was an interesting insight. So do you pay your taxes when you mine? Yeah. So the IRS is crystal clear on this. They say if you mine or if you receive staking rewards, clearly income. That's what they say. And The thing is, there's a recent tax case as of a few months ago. There's a family called the Jarretts, and they did pay their taxes too. They were staking on, I'm not sure how you pronounce it. Is it Tezos, okay, whatever it is. They were staking, they paid their taxes, but then they thought about it and they said, well, wait a second, income. I mean, this income implies I provided some kind of service and I guess the blockchain paid me. And okay, fine, I understand that the IRS understands it this way, but the way that they saw it is that, well, what I actually did is this is newly created property. I mean, I staked what I had and I created new digital assets. So that's newly created property, kind of like a factory creating a chair or baking a loaf of bread. I mean, it's not taxable when the chair comes off the factory line or when you just take the loaf of bread out of the oven. It's only, that would only be taxable when and if you sell it. So I thought this was kind of interesting. I hadn't thought about it this way, but it seems a little bit compelling. So what happened? Well, filed for a refund, made this argument. The IRS said, fine, you can have your refund, which was interesting. Now, the Jarretts understood what was happening here. The IRS probably offered a refund because they were afraid of this argument. They said, well, I don't want this to go to court. I mean, yikes, this seems kind of compelling. So they offer a settlement, meaning there's no precedential value whatsoever. The Jarretts understood this. They said, no, we're going to take it to court. But then the IRS, they filed a motion to dismiss the case entirely. Why? They said it was moot. Why? Because the IRS said this was about a refund. We agreed we'd give it. What is there left to talk about? According to the Jarretts, the Jarretts said, well, this applies to every single other tax year. I mean, just every single year. How could this possibly be moot? Well, the judge agreed that it was moot. They appealed, and actually fairly recently, just a few weeks ago, it was upheld. The dismissal was upheld. So we didn't learn anything from this, right? But is the issue settled? No. I mean, the court did not comment at all about the merits of the case. So what's the takeaway here? Well, I don't know. I mean, if you've mined or if you have staking rewards or mining rewards, maybe file for a refund. Maybe they'll offer you a settlement too. I don't know. I mean, it's possible. If they really are afraid of this issue going to court, you might be able to do it. And it would not shock me if the IRS's position is, we'll give a refund to those who complain about it or make the argument, and we just hope that no one else does. But anyway, I don't know. I thought that was interesting. I mean, I've mined and staked, and I just never thought of that argument before. So again, in conclusion, going back to the securities discussion, there is no conclusion. The regulatory landscape of the crypto industry is still evolving, and there are plenty of landmines out there to navigate, some of which, for all intents and purposes, are invisible. So good luck with that. Perhaps next time I'll have better news to share, but until then, that's all we got.
We do want to say thank you because Fredrikson was one of our sponsors as well for this event. So.